examination or witnesses. Section 1 examination to be done in open court. The examination of witness presented in the trial or hearing shall be done in open court and under oath of affirmation unless the witness is incapacitated to speak, or the questioning calls to for a different mode. Answer of the witness should be given orally. Section 2, that is proceeding to be recorded. Proceeding to be recorded, the entire of proceeding of the trial hearing is including the question propounded to the witness and or her answer thereto, and reference to the case shall be recorded by means to shorthand, then stenotype of or by other means the recording found suitable by the court. So the transact the transcript of the record of the proceeding made by the official stenographer, then stenotypist or recorder, and the center file then correct by him or her shall be deemed primacy of correct then statement such a proceeding. Then section 3 is rights of obligation of a witness. A witness must answer the question, then although he heard the answer may tends to establish claim of against him to her, however is the right of witness. So number 1 is to be protect from irrelevant, improper, outstanding, insulting question in the from harsh or insulting demeanor. Then number 2, that is not be detained longer than the interest of justice require. So number 3, that is not to be examined except only as to matters pertinent to the issue. So number 4, not to be give an answer which will be tend to subject him or her to partially for an offense unless otherwise provided by law, or not to give the answer which will tend to disgrades to his her and reputation unless to be the very fact and issue to fact from the fact and issue would be presumed. Then but and the witness must be answered to the fact of his or her previous final conviction for an offense. So section 4, that is order the examination of an individual witness, the order in which an individual witness by examined is as follow. So A, that is direct examination by the proponent. B, that is examination by the opponent. Then C, that is redirect examination by the proponent. D, that is recross examination by the opponent. So section 5, that is direct examination. Direct examination is the examination the chief of the witness by the party presenting him or her in the facts relevant to the issue. Then section 6, that is cross examination. It is supposed then extend then upon the termination of the direct examination, the witness by maybe cross then examination when the adverse to party on any relevant matter, which with sufficient fullness and freedom to test then his, her, and accuracy and truthfulness, and freedom from interest or bias or the reverse into this illicit, then important facts and bearing upon the issue. So now section 7, that is redirect examination, is proposed to extend after cross examination of the witness has been concluded on her, then she may be the examined by the party, calling her and her to explain or supplement his or her then answer given during the cross examination. One, on redirect examination, question and matters not dealt with during cross examination may be allowed by the court in the their discretion. So, recross examination, upon the conclusion of the direct examination, the adverse party may recross and examine witness and matters attend in his or her direct examination is also such as a matters as may be allowed by the court in its discretion. So, Section 9, that is recalling witness. After the examination of a witness by both sides has been concluded, the witness cannot be recalled without leave in court. Then the court will be granted and without leave in discretion as the interest the justice may be required. So section 10, that is leading and misleading question. That is a question which is suggest to the witness answer which is the examining part of desire leading question, it is not allowed except. So A, that is on cross-examination, then B, that is preliminary matters, C, when it's difficult getting direct, intelligible, then answer from the witness who is ignorant, child of tender years, and feeble, and might defame mute. So D, that is of unwilling, hostile witness. Then A, that is a witness who is an adverse party of the officer, then director, then managing agent of the public, private, then this reason, then partners, private corporation of a partnership association which an adverse party.